Good morning, this is your Kelso Report for May 16th, and I'm your host, Clark Kelso. Excuse my hoarse voice today. I'm still coming off of a cold. It sounds a lot worse than it feels, I can assure you. We have cases today dealing with the death penalty, securities laws, arbitration, criminal procedure, and juvenile law. We're going to begin with a couple of death penalty cases from the Ninth Circuit Court of Appeals. First, a habeas decision. Facing an imminent execution date, the petitioner filed his second appeal to the Ninth Circuit, this time seeking review of the district court's denial of a new ineffective assistance claim based on an alleged ineffective assistance of post-conviction counsel, a claim now approved in very narrow circumstances by the Supreme Court in Martinez v. Ryan, decided earlier this year. The Ninth Circuit affirmed the denial, concluding that the district court did not abuse its discretion in denying the petitioner's motion because the petitioner could not show that his underlying claim was a substantial one that had merit, which is what is now required under Martinez. Next, a death penalty decision arising out of proceedings in Arizona. Just 2 months ago, in Towery v. Brewer, a panel of the Ninth Circuit rejected last-minute challenges to the execution protocol used in Arizona. That litigation was a true circus where the state modified the protocol, going from a 3-drug protocol to a 1-drug protocol, mere hours before oral argument in the Ninth Circuit. Well, yesterday the circus continued with a challenge by another defendant, this time in Lopez v. Brewer. This time the defendant argued the protocol violated the Constitution because, among other things, when Towery was actually executed, it took almost a full hour and 6 attempts to insert an IV properly, subjecting Towery to unnecessary pain. The Ninth Circuit rejected the argument, noting that the execution team in Towery had included a person with no medical license demonstrating proficiency for placing IVs, that the state had modified its protocol to require such licensing after Towery, that's a pretty good idea, that 2 executions since then had proceeded without incident, and that the claim is an individual one, not reflecting a systemic problem. The court also denied a requested stay of execution. Next, we turn to securities. The defendant in SEC v. Jasper was the former CFO of a Silicon Valley semiconductor company. The SEC instituted a civil enforcement action against the defendant following revelations that the company had issued backdated stock options without properly expensing them. Following a 7-day jury trial, judgment was entered against the defendant on most claims, resulting in a judgment barring the defendant from serving as an officer or director of a publicly traded company for 2 years, the imposition of a $360,000 fine, and an order from the court directing the defendant to reimburse his former company for $1.8 million in bonuses and profits from sales of company stock that the defendant received during the period he certified the false financial statements. The Ninth Circuit rejected several inconsequential evidentiary objections, as well as a claim of SEC lawyer misconduct. The most interesting argument was that the reimbursement order pursuant to Sarbanes-Oxley violated his Seventh Amendment right to a jury trial, a claim that the Ninth Circuit rejected by noting that the remedy is actually an equitable remedy, essentially disgorgement of profits, for which there is historically no right to a jury. Next, we turn to arbitration. That feels a little better. A workers' comp insurance company entered into a contract with its client which contained an arbitration clause. The insurance company also required the client to enter into a separate contract with a separate company to serve as the third-party administrator for workers' comp claims. This separate contract did not contain an arbitration clause. When the insurance company sued the client for failure to pay some $3.5 million in premiums and reimbursement of workers' comp insurance claim deductibles, it invoked the arbitration clause. The client responded by suing the third-party administrator for breach of contract and tortious breach of the covenant of good faith and fair dealing, claiming the third-party administrator had mishandled the client's claims. The third-party administrator then demanded arbitration, and the trial court held that because the claims against the third-party administrator were inextricably intertwined with proper interpretation of the underlying insurance contract, which contained a broad arbitration clause, the client was estopped from resisting the third-party administrator's demand for arbitration, even though the contract between the third-party administrator and the client did not contain an arbitration clause. Well, in DMS Services versus Zurich Services Corp., the Second District found in favor of the client. Although the court recognized that there are indeed some circumstances where claims in one contract may be so intertwined with claims in another contract so as to trigger estoppel, those circumstances simply did not exist here, given the complaint filed by the client. The claims in the complaint simply did not depend for their resolution upon resolution of issues arising under the underlying insurance contract. And absent that intertwining, it was improper to try to foist upon the client an arbitration clause that appeared only in the underlying insurance contract. Next, a case involving criminal procedure. In People v. Kendrick, the issue before the First District was whether a district attorney could file a motion extending the commitment to a state hospital of a person who had pled not guilty by reason of insanity, even though the state hospital director did not recommend the extension. The trial court granted the motion to extend under Section 1026.5 of the Penal Code, which governs the procedures for extending the commitment of persons found not guilty by reason of insanity. The appellant tried to rely upon a few cases under Penal Code Section 2970 of the Mentally Disordered Offender Act, which held that a prosecutor lacks statutory authority to file a petition to retain an MDO unless the hospital medical director recommends the extension. The First District noted that there were other cases to the contrary under Section 2970, and that the statutory language in Section 2970 was slightly different from the language in Section 1026.5. So the First District affirmed the trial court's judgment here, concluding that the medical director's recommendation against extending the commitment did not preclude the district attorney from filing a petition, and that substantial evidence supported the order extending the commitment because of evidence the appellant still presented a substantial danger of physical harm to others. The court's conclusion here has to be correct. It is highly unlikely that the legislature would have intended to give the hospital medical director sole authority to determine whether someone's commitment could be extended, especially since public safety factors play into that determination. And finally, a case involving juvenile law procedures. In the context of a set of hearings to determine placements for a brother and sister, the trial court approved a motion from the county social services agency to administer psychotropic medications to the boy to reduce his increasingly dangerous tantrums. Under California Rules of Court Rule 5.640C8, any opposition to that motion must be filed within only 2 days of when the motion is received. The mother filed her opposition, but the trial court granted the motion anyway. On appeal, the mother contended the 2-day time frame for filing an opposition denies due process because it simply isn't enough time to respond. In re AS, the 4th District rejected this argument. Because of the exigencies of any motion for involuntary administration of psychotropic medication, the statute which authorizes such an order requires the court to decide the motion within 7 days of when the motion is made. Given that emergency context, a 2-day time for filing an opposition is not, on its face, unlawful. The court here does refer to the Judicial Council a technical drafting problem with the rule. As drafted, it starts the 2-day clock running when the motion is received. Well, that's an unreliable indicator, as the court points out, and the rule perhaps should be amended to start the clock upon service of the motion, something that you can determine a little bit more objectively. And that's it for today's Kelso Report. Have a great day in the law.